Good morning. Oh, stretching it out. Good morning, Bumblebee, mic dropping. Welcome to Truth and Transparency. Saturday morning, going to discuss today Jamie Brown's petition for post-conviction relief. So, welcome everybody. Welcome, New Orleans lady. I need this live. My daughter had a baby 2 weeks ago tomorrow and almost died. Well, prayers for you and your family. Again, hello to all the live viewers. Hello, Patty, Bumblebee, mic dropping. Glad you guys could catch a live. Again, this live is, I'm going to be reading off the petition for the post-conviction relief. Going to give people a chance to let their notifications hit in. Let's see. Oh, you're very welcome, New Orleans lady. Alrighty. Again, hope you guys are having a good morning. If you are across in other parts of the world, it may be afternoon, whatever it is for you. Hopefully it finds you well. Again, this is Lana Oriani, Truth and Transparency. Thank you guys for being here. And again, this is going to be, it's going to help people that are following along with Sunset Secrets Season 2. Just as well as keeping up with the facts surrounding, this is in real time. And Jamie Brown has filed, with, for his post-conviction relief with Pennsylvania. And he also actually has a federal, waiting on a habeas corpus with federal. So, all right, I'm going to go ahead and get started. That picture that is up, that is Jamie Brown being taken in. This is back in, like I said, 2001. Jamie Brown was arrested for the ambush murder of Aliquippa police officer. Okay, here we go. Again, trying to give people a chance here. Delaney, Charlie Faith, welcome. Mod Squad, don't worry about it. You're all good. All right, petition for post-conviction relief. Again, this was filed in the springtime, right around May 2021. And here it goes. And now comes petitioner Jamie Brown. by and through his attorney, files this petition for post-conviction relief. Petitioner Jamie Brown is currently housed in State Correctional Institute. He has been incarcerated SCI Forest since 2005. On or about March 17th, 2001, Mr. Brown and A.C. Taylor III were arrested and charged with criminal homicide in connection with the shooting death of Aliquippa Police Officer James Naim. Officer Naim, while on foot patrol in Lindmar Terrace, Aliquippa, Pennsylvania, was shot in the side of the head on March 15, 2001 at approximately 8:15 p.m. and died as a result. Individuals in the area identified observing then 19-year-old Darnell Hines in the area after the shooting. Mr. Hines, who had poor eyesight, was promptly arrested and ultimately charged with capital murder for killing Officer Naim. Immediately after his arrest, Mr. Hines was physically assaulted and threatened by Aliquippa police. Police demanded that he implicate Mr. Brown. See post-remand amended PCRA petition for 2817, attachment D. Mr. Hines, while incarcerated, informed Sergeant Matthews that he had not witnessed the shooting, but that his own attorneys were urging him to implicate Mr. Brown to save himself. After being incarcerated for approximately 1 month and fearing the death penalty, Mr. Hines made a statement that he saw Mr. Brown shoot Officer Naim. Mr. Hines would later testify at trial against Mr. Brown and his co-defendant A.C. Taylor III. According to Mr. Hines, Mr. Taylor was present for the shooting and stated, quote unquote, "That motherfucker ain't dead, shoot him again." Mr. Hines subsequently recanted his trial testimony concerning Mr. Brown to then Aliquippa Assistant Police Chief Joe Percival in 2016. That was also put in the post-remand amended PCRA petition that was done for 2817 attachment D. On March 17, 2001, Mr. Brown was also arrested and charged with criminal homicide. Before his death, Officer Naim informed 4 separate individuals that he was concerned for his life because there were quote-unquote dirty Aliquippa police officers. The Commonwealth successfully precluded the introduction of evidence that Officer Naim informed his brother, a newspaper reporter friend, and Joseph David that he feared that fellow officers would take his life. The court ruled that any such evidence would be inadmissibly, it was hearsay. The court also granted a Commonwealth motion to preclude evidence that Anthony Two Sweet Smith was the perpetrator of the killing. More specifically, the court precluded evidence from Priest, Ellis, and Griffey regarding discussions that they had with Smith, which Smith was attempting to pay someone approximately $20,000 to kill an Aliquippa police officer. In addition, Two Sweet Smith was also seen with 2 9mm handguns and had indicated his intent to kill an officer while riding in a vehicle. A 9mm magazine with 26 rounds was discovered at the home of Wallace, where Anthony Two Sweet Smith ordinarily resided. In addition, police located 1 box of UMC brand 9mm ammunition containing 42 rounds. 3 9mm rounds were also recovered inside a Sega video game system. See supplement to amended PCRA petition on 9/21/2017 It was the Killigan Homicide Investigation Action Report. The bullets recovered from the Wallace Smith residence were considered, quote-unquote, bullets of a possible match to those found at the crime scene. None of this evidence was introduced at trial. In footers here, the trial court declined to grant a Commonwealth motion to preclude testimony from Burrell and Fisher that shortly before the shooting, Sweet Smith was with those individuals in a car with two 9mm handguns and instructed Mr. Burrell to drive around the block when they saw an Alcoa police officer. Mr. Smith loaded one of the guns and said, quote-unquote, we got to get one. Trial counsel, however, did not include that evidence. Anthony Sweet Smith's grandmother also resided in Linmar Terrace, where the shooting occurred, and a dog began to track the killer toward that residence before losing the scent. See PCRA Court Opinion 10/16/2017. Miss Johnson also informed police that she saw a man fleeing from the area behind her house after hearing shots fired, which was in the area the dog had last tracked and toward Sweet Smith's grandmother's home. Sweet Smith left from Linmar to the Pittsburgh airport and flew to Nashville, Tennessee under a false name the night of the shooting. Sweet Smith also made a jailhouse confession to a Mr. Richard DiSabatino, see Exhibit 2, supplement to the amended PCRA petition on 9/21/2017. Similarly, Mr. Smith told another inmate that Jamie Brown was doing Sweet's time and that Sweet, quote-unquote, killed the pig. Exhibit 3, see also post-remand amended PCRA petition on 4/28/2017, attachment F. The latter information was not learned of until after Mr. Brown's trial. Mr. Taylor, prior to trial, provided a coerced statement to police in which he implicated Mr. Brown. Mr. Taylor did not testify at trial, but his statement was introduced with Mr. Brown's name replaced with the term, quote-unquote, the other guy. During the Commonwealth's case, it introduced a large aerial photograph of the area that had been marked based on Mr. Taylor's representations. The Commonwealth failed to redact the initials JB from the photograph that it initially displayed. A request for a mistrial was denied, and the court declined to give a cautionary instruction. Like Mr. Hines, Mr. Taylor subsequently recanted his statement to then Assistant Chief of Police Joseph Percival. Please see Exhibit 4, post-remand amended PCRA petition on 4/28/2017, attachment C. The Commonwealth's case rested largely on the testimony of Darnell Hines and his nighttime eyewitness identification. In addition, the Commonwealth relied on false testimony from Joseph Kirkland, a known snitch who claimed that he saw Mr. Brown speeding in a red car in Linmar Terrace, and that Mr. Brown told him later that night that Mr. Brown had put a bullet in the man's head. In the footers here, Mr. Brown's trial predated the Pennsylvania Superior Court's authorization of admission of expert testimony on the fallibility of eyewitness identification. Kirkland had then pending charges for rape, which were withdrawn in exchange for him pleading no contest to corruption of a minor. No other witnesses who testified observed Mr. Brown in the area, and Mr. Brown pro-offered an alibi defense. On May 10th, 2002, after 4 days of deliberations, Mr. Brown was found guilty by a jury of third-degree murder, and Mr. Taylor, his co-defendant, was acquitted. On May 29th, 2002, Mr. Brown was sentenced to a term of incarceration of 20 to 40 years. Mr. Brown appealed, and the Superior Court affirmed the trial court on February 23rd, 2004. The Pennsylvania Supreme Court denied Mr. Brown's petition for allowance of appeal. Mr. Brown's judgment of sentence became final on or about March 3rd, 2005. Mr. Brown timely filed his first PCRA petition on June 30th, 2005. See the PCRA petition on 6/30/05. And the court appointed PCRA counsel, who filed an amended petition on March 20th, 2006. See amended PCRA petition 3/20/2006. The PCRA court conducted an evidentiary hearing on November 1st, 2006. At the conclusion of the hearing, PCRA counsel asked that the record remain open. However, PCRA counsel subsequently withdrew, and substitute PCRA counsel was appointed. Substitute PCRA counsel incorporated the prior PCRA counsel's claims and alleged additional issues concerning direct appeal counsel's representation. The PCRA court declined to reconvene the evidentiary record and denied Mr. Brown's initial petition on February 13th, 2008. Mr. Brown appealed, and the Superior Court affirmed on December 31st, 2008. One of the grounds for relief sought therein was the recantation of Mrs. Lee. Miss Lee, a former sex partner of Mr. Brown, testified during Mr. Brown's trial and claimed that Mr. Brown had threatened to kill a cop in her presence. She subsequently recanted and set forth that she testified in that manner because she was angry that nude pictures that Mr. Brown had taken were distributed and eventually shown to her son. She also indicated in her recantation that the Commonwealth coerced her into making false statements against Mr. Brown, a consistent theme in this matter. The Pennsylvania Supreme Court denied allowance of appeal. That was Commonwealth v. Brown, PA 2009. Thereafter, Mr. Brown litigated an unsuccessful federal writ of habeas corpus, which was denied on March 20th, 2012. The Third Circuit Court of Appeals denied Mr. Brown's certificate of appealability, and the Supreme Court denied. The court denied the petition on July 26, 2012. Mr. Brown appealed, and the Superior Court treated the petition as a PCRA petition and affirmed on August 9, 2013. On April 22nd, 2013, Mr. Brown received a notarized letter dated April 17th, 2013, authored by Angela White. After receiving the affidavit, Mr. Brown obtained transcripts from Mrs. White's own criminal case from Miss Reed, which made mention of wiretap recordings that included discussions relative to Officer Naim's death. Angela Brown was in the military out in Texas, by the way. We'll get into her. Mr. Brown thereafter obtained the transcripts relating to a criminal proceeding in Beaver County related to Miss White. Mr. Brown filed a motion under 28 U.S.C. 2244 for an order authorizing the federal district court to consider his second application for relief under 28 U.S.C. 2254 based on the Angela White affidavit. That motion was denied. Mr. Brown also filed a pro se serial PCRA petition on June 7, 2013, within 60 days of learning of Mrs. White's letter. The PCRA court denied Mr. Brown's petition on December 22, 2014, without a hearing. Mr. Brown timely appealed. The Superior Court, in a published decision, affirmed in part and vacated in part on March 24, 2016, Commonwealth v. Brown. The Superior Court further directed the PCRA court to appoint counsel and conduct an evidentiary hearing. Prior to the record being remanded to the PCRA court on April 13, 2016, Mr. Brown received a signed statement dated April 8, 2016, from co-defendant A.C. Taylor. Exhibit 4, post-remand amended PCRA petition, 428, 2017, attachment C. Therein, Mr. Taylor asserted that after 10 hours of interrogation, he falsely implicated Mr. Brown. Mr. Taylor further indicated that police detained him for 6 hours without counsel and refused him food and water. Notably, Mr. Taylor was a juvenile at the time. Thereafter, police brought Mr. Taylor's father into the interrogation room and threatened his father with jail time. According to Mr. Taylor, police coerced him into making false statements and provided him with information to use to implicate Mr. Brown. On or about April 29, 2016, Mr. Brown also received an affidavit from Darnell Hines, dated April 24, 2016, Exhibit 1, post-remand amended PCRA petition, 428, 2017, attachment D. Motion for leave to file amended PCRA and amended petition on 5/23, 2016. Mr. Hines recanted his trial statement that he observed Mr. Brown committing the shooting. He indicated that he only informed police that he saw Mr. Brown because police continually told him that it was Mr. Brown who killed Officer Naim. Police beat Mr. Hines and called him the N-word. And due to fear, on May 6, 2016, the PCRA court appointed counsel. Again, because Jamie Brown was doing a lot of this pro se. Before Mr. Brown learned of the appointment on May 23, 2016, and within 60 days of learning of the Hines and Taylor statements, he filed a motion for leave to file amended PCRA and an amended petition. Therein, he provided the affidavits and statements from A.C. Taylor and Darnell Hines. Mr. Brown, on July 18, 2016, requested a change in appointed counsel after appointed counsel refused to address the new evidence from Mr. Hines and Mr. Taylor. On July 27, 2016, the PCRA court denied Mr. Brown's pro se request to amend his petition and the motion for change of counsel. On September 14, 2016, appointed counsel filed an application for relief with the Superior Court seeking the wiretape records discussed in the published Brown decision. Also here in the footers, information disclosed in discovery revealed that Mr. Hines' IQ was in the 70s range. He was considered mildly mentally challenged, and that he was considered to have a third grade educational level and was easily manipulated. The Superior Court denied that request without prejudice on October 5, 2016, and indicated that counsel first seek the requested relief with the PCRA court under PA Crem P 902. On November 15, 2016, appointed counsel filed an amended petition on behalf of Mr. Brown, amended petition 11/15, 2016. On January 10, 2017, the PCRA court entered an order to direct the Superior Court to provide the wiretap evidence related to Michael Glanton, Angela White, Mr. Smith, and cancel the scheduled January 23, 2017 hearing. Prior counsel filed with the Superior Court on January 11th, 2017, an application for relief, which attached the PCRA court order of January 10th, 2016, and requested that the Superior Court provided wiretap recordings from 12-1 WD 2001. The Superior Court on January 12th, 2017, again denied the request without prejudice and directed prior counsel to comply with the Superior Court IOP. Thereafter, on February 10th, 2016, previous counsel filed an additional amended PCRA petition. The PCRA court scheduled a status conference for March 23rd, 2017. The undersigned, who is entered right now, his appearance on February 27, 2017, and currently is Jamie Brown's representation. The status conference was rescheduled for April 24, 2017. Following the status conference on or about May 8th, 2017, so about 2 weeks later, the undersigned filed a joint motion to unseal pursuant to Pennsylvania Superior Court IOP 6575, seeking wiretap information at 12-1 WD 2001. The Superior Court granted that order on May 30th, 2017. The PCRA court, the prosecution, Jamie's attorney, reviewed record from 12-1 WD 2001 during proceedings on June 9th, June 12th, and June 13th of 2017. That record consisted of wiretap recordings of 2 separate phone calls of Michael Glanton on June 23rd, 2017, based in part on review of the wiretap record. Mr. Brown filed a joint motion to unseal with the Pennsylvania Superior Court related to the wiretap records at 12-2 WD 2001 and 12-3 WD 2001. 12-2 pertained to wiretap recordings of Mr. Smith, the brother of Anthony Too Sweet Smith, and 12-3 related to recordings of Michael Bigstaff. The Superior Court granted that request on July 17th, 2017. Thereafter, on July 21st, 2017, the Superior Court amended its July 17th order, which had required copies to be made of the wiretap record. It also entered in an additional order on July 21st, 2017, providing for the handling of the wiretap records. From July 31st through August 3rd of 2017, the parties reviewed the additional wiretap records. After the conclusion of the review of the wiretap wiretap recordings, the court authorized Mr. Brown to file additional relevant motions. Accordingly, on September 21st, 2017, Mr. Brown filed a motion to secure attendance of an out-of-state witness and a supplemental amended PCRA petition and request for evidentiary hearing. In addition, on September 24, 2017, he filed a discovery motion. In the discovery motion, Mr. Brown requested disclosure of any investigative files maintained by the Alcova Police Department, Beaver County Detectives, the Office of Attorney General, the Pennsylvania State Police, and any information provided by the FBI, the state or local law enforcement as it relates to any investigation of Anthony Too Sweet Smith, Michael Glanton, Mr. Smith, and their involvement in the murder of Officer Naim, including but not limited to any statements provided by Mr. Dorsett. Motion for discovery was 9/24/2017. In addition, Mr. Brown asked for copies of any police files maintained by the Alcova Police Department, Office of Attorney General, Pennsylvania State Police, Beaver County detectives, and any information provided by the FBI to state or local law enforcement pertaining to a parallel drug investigation of the Smith brothers and Michael Glanton. Lastly, Mr. Brown asked for quote-unquote investigative files maintained by the Aliquippa Police Department, Beaver County detectives, the Office of Attorney General, the Pennsylvania State Police, and any information provided by the FBI into possible Aliquippa police corruption at the time of Officer Naim's death, not limited to grand jury information. None of the requested discovery was provided, and the PCRA court denied the discovery request. Despite this denial, as outlined below, Mr. Brown, during the pendency of his prior PCRA appeal, learned of exculpatory information provided by Mr. Dorsett. The PCRA court, on September 26, 2017, scheduled an evidentiary hearing solely as to the Angela White issue for November 29, 2017, and granted Mr. Brown's request to secure the out-of-state witness, Miss Angela White. Nonetheless, the court declined to grant a hearing on the additional newly discovered fact and after discovered evidence claims related to Mr. Hines and Mr. Taylor. It based this denial on its belief that the Superior Court's prior remand did not grant it jurisdiction to hear any claim other than Mr. Brown's Angela White issue. The PCRA court reiterated this position on October 12, 2017, in its memoranda and order denying Mr. Brown's supplemental discovery request. It did not address the plain language of the PCRA statute that required newly discovered facts to be raised at that time, within 60 days of discovery. Mr. Brown testified during the previous PCRA hearing as the following. Mr. Brown has no internet access and could not access docket sheets of any criminal cases. Only recently had Mr. Brown been able to obtain email access. In this respect, Mr. Brown could only email individuals who pay for and set up an email account with the prison system. In order to set up an email account, the non-incarcerated individual must contact the Department of Corrections and submit information so that a background check can be concluded. If the non-incarcerated individual is approved, then that person must contact a separate company and pay money that allows them to send and receive emails from an incarcerated individual. Mr. Brown also cannot call any individual he wishes. Phone calls can only be placed to individuals on a phone list. In order to be placed on a phone list, the incarcerated person must submit a name, phone number, and date of birth to his counselor. The counselor will then conduct and check, and the person may be approved or disapproved for addition to the phone list. A phone list can only be changed once a month. In order to visit an incarcerated individual, the person must be placed on the incarcerated person's visitors list. The prisoner must complete a visitor add-on form, including the person's name, address, date of birth, and provide that to the prisoner's counselor. The prison will then conduct a background check to approve or disapprove of this visitor. Mr. Brown is not permitted to contact individuals who are in a state correctional facility, nor is he permitted to contact individuals on parole. Angela White was on parole. A.C. Taylor was also incarcerated in state prison. Mr. Brown further testified he can only visit the law library twice a week for up to 2 hours. To schedule a visit to the law library, an inmate must submit a request 2 weeks in advance, providing 4 days in which he would like to visit the law library. The prison then will give the prisoner 2 days of the days requested to visit the law library, and there is a 2-week lag time between requests and actual visits. The law library does not provide internet access and only contains books and pre-programmed computers. Thus, an inmate cannot conduct internet searches. Prisoners must rely on individuals on the outside, like myself and like all of you, in order to assist them in ascertaining new evidence. Mr. Brown has continuously and regularly written and called family members to beg them for assistance. Mr. Brown also asked his former attorney, Erica Kreisman, to assist him even after he filed his original PCRA against her for ineffective counsel. Family and friends would provide newspaper articles that would mention names of individuals who were involved in the case, as well as rumors that they or other persons may have heard. Mr. Brown would then compare that information with the discovery he received as part of his criminal case. Mr. Brown also wrote to the Innocence Institute at Point Park University seeking assistance in his case. On September 21st, 2019, the PCRA court denied Mr. Brown's PCRA petition. Importantly, on the issue that the Superior Court remanded whether Mr. Brown exercised due diligence, the court found that Mr. Brown did exercise due diligence. Mr. Brown timely appealed on October 5th, 2018. During the then ongoing appeal on November 2nd, 2018, his attorney that he has right now acquired additional newly discovered facts and evidence. Specifically, an individual named Dawkins was transferred to SCI Forest where Mr. Brown was incarcerated. Mr. Dawkins is from the Aliquippa area and was incarcerated for homicide. Dawkins, who knew Mr. Brown's younger brother, had just recently been transferred to SCI Forest from federal prison and informed Mr. Brown that as part of his criminal case in Beaver County, he had received in discovery a statement made by Anthony Dorsett as part of Dorsett's federal plea deal in 2009, which required Dorsett to provide truthful information concerning homicides in Aliquippa. Present for the interview in question was Beaver County Detective Anthony McClure, who testified at Mr. Brown's trial, and Pennsylvania State Trooper Michael Warfield, and the information was provided to the Beaver County District Attorney's Office. As part of the plea deal requiring Dorsett to provide truthful information concerning a variety of homicides in the Aliquippa region, Dorsett informed federal and state authorities that Anthony Too Sweet Smith confessed to him to killing Officer Naim. The undersigned met with Dawkins at SCI Forest, and Dawkins also wrote to the undersigned and authorized the undersigned to have access to his discovery. Almost immediately on November 2nd, 2018, counsel obtained the discovery in Dawkins' case, including the federal plea deal of Dorsett. Mr. Brown could not raise the Dorsett issue in his prior PCRA proceedings within the 60 days, the then applicable time to bring newly discovered evidence in state court PCRA proceedings, because his case was then on appeal. Commonwealth v. Lark by Commonwealth v. Small, the facts upon which appellate based his claims were not known to him and could not have been discovered in the exercise of due diligence until that date. At that time, his first PCRA petition was pending on appeal before this court. Within the 60 days of the order denying relief pursuant to his first petition, he filed his second petition. Thus, we find that the presentation of the claim regarding the McMahon tape in the second PCRA petition was timely. During Mr. Brown's appeal, the PCRA time bar was altered to permit petitioners to raise newly discovered facts within 1 year of discovery. I need to take some water here. Woo! A lot of reading. It should be on the side.
Got gold? Chardonnay?
Pursuant to Lark and the new one-year time period to raise a timeliness exception to the PCRA time bar, Mr. Brown had until at least June 10th, 2021 to timely file his newly discovered evidence claim related to Mr. Dorsett. Here's a sub footer here. June 10th, 2020 is when the Pennsylvania Superior Court denied Mr. Brown's appeal. He had 90 days to seek with the United States Superior Court. Thus, it is arguable that the one-year period did not begin to run until the expiration of that period. Commonwealth v. Lark, Commonwealth v. Small. That is what he is. That's what Jane Brown's attorney is putting in this with case law. The Superior Court denied Mr. Brown's most recent PCRA appeal on October 2nd, 2019. In doing so, the Superior Court declined to address the Hines and Taylor claims on the basis that those claims could not be raised following the remand on the Angela White claim, but must await review. The Pennsylvania Superior Court denied Mr. Brown's petition for allowance of appeal on June 20th, 2020, from the denial of review of Mr. Brown's claim related to the lower court's refusal to consider the Hines and Taylor evidence. Because the PCRA court and Superior Court did not consider the merits of and did not rule on Mr. Brown's timely raised newly discovered fact and after discovered evidence claims pertaining to Darnell Hines and A.C. Taylor, Mr. Brown had 1 year from the conclusion of his prior PCRA matter to raise those claims. Mr. Brown's claims on newly discovered evidence, which, when viewed with the evidence as a whole, established that, but for the Commonwealth's actions and inaction, no reasonable fact-finding would have found Mr. Brown guilty. Mr. Brown's petition is timely under both the newly discovered fact timeliness exception and the governmental interference timeliness exception. A petition is timely where, quote unquote, the facts upon which the claim is predicted were unknown to the petitioner and could not have been ascertained by the exercise of due diligence. This timeliness exception does not require that a petitioner establish that he is entitled to relief. Rather, the exception requires only that the facts the claim are based on to have been unknown and could not have been learned through the exercise of due diligence. Commonwealth v. Lambert, Commonwealth v. Bennett. Further, to be a newly discovered fact does not require the fact to be admissible evidence, and that is Commonwealth v. Chimmel. Mr. Brown, in footers here, time for filing petition. Any petition under this subchapter, including a second or subsequent petition, shall be filed within 1 year of the date the judgment becomes final, unless the petition alleges that the petitioner proves that the failure to raise the claim previously was the result of interference by government officials with the presentation of the claim in violation of the Constitution or laws of this Commonwealth or the Constitution or laws of the United States. Government officials were told in 2012 when Mr. Dorsett made his deal. And part of the deal, as I will continue to read, is that Mr. Dorsett could not lie to get his deal. Mr. Brown exercised due diligence in attempting to preclude evidence to establish his innocence. In this report, courts must be attentive to each petitioner's quote-unquote circumstances, and in particular, quote-unquote, take into account that prisoners are limited by their physical confinement. Explaining that due diligence does not, quote-unquote, expect efforts on the part of a lay person who is a convicted and incarcerated person. Jamie's attorney goes on to discuss a couple which are very important, and I'm going to be continuing to read here. But Jamie did a lot of his PCRAs pro se. Okay, yes, he does have an attorney now, and he has had one since 2017. At the end of this, when I tell you what happened from this was filed 2021 in May. When I tell you what Judge Mancini claimed and how he wrote what he wrote, I'm shocked at the language. Moreover, as it relates to Mr. Brown's Brady claim, so if Kim Kaufman's listening, this is right up your alley with Brady. Moreover, as it relates to Mr. Brown's Brady claim, the Dorset information, it must be highlighted that a defendant's lack of independent investigation does not equate to a lack of due diligence, at least not without facts giving him a reasonable basis to suspect a Brady violation. To the contrary, in the typical case, it is unreasonable to expect that the petitioner to harbor suspicions that the government is defying its obligations. The government did not turn over Mr. Dorset's information that pertained to his case. Further, in order to preserve the issues, Mr. Brown asserts that the interpretation of the 1-year time bar is incorrect as a matter of statutory construction. See Thomas M. Place, claim is recoverable. That's all just giving the references of it. Additionally, if considered, the time bar is unconstitutional as applied, where Mr. Brown is factually innocent and governmental misconduct precluded Mr. Brown from learning during his previous PCRA proceedings of the Brady after discovered evidence discussed herein, and law enforcement coerced Mr. Hines and Mr. Taylor to implicate Mr. Brown. To find the petition untimely would violate Mr. Brown's state substantial and procedural due process rights under Article 1 and his federal substantiated procedural and due process rights. So this is federal and state. His rights be violation of them. Mr. Brown was previously represented in his state court proceedings by Erica Kreisman at trial, Mark Rubinstein at sentencing, and Jeffrey Small during his direct appeal. During his first counseled PCRA litigation, he was initially represented by Timothy Carland and thereafter by Stephen, I don't want to botch this name, as Valsmides. Mr. Brown was also initially represented by attorney Sherry Hurst following the Superior Court remand in his prior PCRA matter. Mr. Brown requests a new trial. The grounds for the relief requested have not been previously litigated, nor are they waived. Mr. Brown is actually innocent. That is, he did not shoot and kill the victim in this matter, and that his conviction was a miscarriage of justice. His attorney filing the petition are authorized to do so on petitioner's behalf. Mr. Brown raises the following merits, and these are the grounds for relief. Mr. Brown is entitled to a new trial based on after discovered evidence in the form of recantation from Commonwealth witness Darnell Hines, wherein the government improperly coerced Mr. Hines and Mr. Brown's due process right to a fair trial was denied, and such new and reliable evidence of Mr. Brown's actual innocence, when viewed in the light of all of the evidence in the case, is sufficient to establish that no reasonable juror would have found Mr. Brown guilty, absent constitutional error. Mr. Brown is entitled to a new trial based on after discovered evidence in the form of recantation of his statement to police from A.C. Taylor, Mr. Brown's co-defendant, where Mr. Taylor was improperly coerced by the government and Mr. Brown's due process right to a fair trial was denied, and such new and reliable evidence of Mr. Brown's actual innocence, when viewed in the light of all the evidence in this case, is sufficient to establish that no reasonable juror would have found Mr. Brown guilty absent constitutional error. Mr. Brown is actually innocent and is entitled to a new trial based on the after discovered evidence, to wit, Anthony Ali Dorsett's federal plea deal, in which he implicated Anthony Too Sweet Smith as the person who killed Officer Naim, and which was never disclosed to Mr. Brown in violation of Brady, where such new and reliable evidence of Mr. Brown's actual innocence, when viewed in light of all the evidence in the case, establishes by clear and convincing evidence that no reasonable juror would have found Mr. Brown guilty absent constitutional error. Mr. Brown is entitled to an evidentiary hearing to demonstrate that his claims are timely and that he has exercised due diligence in attempting to uncover evidence in his favor. Further, Mr. Brown requests an evidentiary hearing to establish the merits of his claims and his actual innocence. To be entitled to relief under the PCRA, a petitioner needs to show, by a preponderance of evidence, that his conviction resulted from a violation of constitutional rights, ineffective assistance of counsel, and the unavailability at the time of trial of exculpatory evidence that has subsequently become available and would have changed the outcome of a trial if it had been introduced. The preponderance of evidence standard is low. Indeed, it is the lowest burden of proof and only requires the evidence to tip the scale slightly in one's favor. Commonwealth v. AR. Mr. Brown is entitled to a new trial based on after discovered evidence in the form of a recantation from Commonwealth witness Darnell Hines, wherein the government improperly coerced Mr. Hines and Mr. Brown's due process right to a fair trial was denied. Mr. Brown incorporates the prior paragraphs as if fully set forth herein, and then he's talking about in Moore v. Philadelphia, the Pennsylvania Superior Court, to be entitled to a new trial based on after discovered evidence, a party must show, first, that the evidence has come to his knowledge since the trial; second, that it was not owing to want of due diligence; that it did not come sooner; and third, that it would probably produce a different verdict if a new trial were granted. In Commonwealth v. Flanagan, after citing Moore, the Superior Court also reasoned that after discovered evidence, testimony therein must not be solely for the purpose of impeaching a testifying witness, but must go to the merits of the case. Notably, the Flanagan Court relied on People Ulrichs v. Superior Court of City of New York in discussing impeachment and after discovered evidence. That court had held, with respect to granting new trials on the ground of newly discovered testimony, there are certain principles which must be considered settled. 1, the testimony must have been discovered since the former trial. 2, it must appear that the new testimony could not have been obtained with reasonable due diligence on the former trial, which they are claiming that Dorsett was obviously in, that Jamie Brown could not possibly have gotten any of that information prior to when he just, obviously received it. It must be material to the issue. It must go to the merits of the case and not to impeach the character of a former witness. It must not be cumulative. It cannot be denied in this case, and that the testimony offered was material to sustain the point of defense, and that it is not liable to the objection that it goes to impeach the plaintiff's witness. Russell says nothing about the character of the witness, but contradicts the facts sworn in by him. These are all giving examples of case law granting, not denying, granting. And it states Mr. Hines' recantation could not have been obtained prior to the conclusion of trial. Mr. Hines' statement and proposed testimony are not corroborative or cumulative of testimony introduced at trial. Mr. Hines' statement and proposed testimony would not be used solely to impeach the credibility and character of the Commonwealth's witness. Rather, Mr. Hines' testimony is substantiated evidence that Mr. Brown was not present at the time of Officer Naim's shooting, and evidence that Mr. Brown is actually and factually innocent. This substantive evidence that is exculpatory is by definition not solely impeachment evidence. As outlined above, the historical grounds for the impeachment prong of the after discovered test related to impeachment the character of a witness, not evidence that impeaches a witness. In point of fact, any evidence that Mr. Brown is innocent would necessarily, quote unquote, impeach the evidence provided by the Commonwealth. A Pennsylvania trial court addressed an after discovered evidence claim as it relates to impeachment in this regard, Commonwealth v. Mitchell. There, the defendant had been convicted of assault and battery of a child. The only witness to identify the defendant was the mother of the child. Her testimony was that immediately after the attack, the defendant entered a nearby home. The defendant brought forth after discovered evidence from the persons in that home that she was not present at the time of the assault and battery. The Mitchell court reasoned, this is not simply cumulative or corroborative or impeaching evidence, unavailing under the familiar rule as newly discovered evidence, warranting a new trial. It may indeed incidentally or indirectly cumulative or corroborate and impeach, but in view of the Commonwealth's evidence just referred to, its main office and direct effect are to deny the identity of the assailant with the defendant, and therefore the truth of the charge made against her by proof of her absence from the place where she is said to have been immediately after the assault. The same is true of Mr. Hines' statement and proposed testimony, which main effect is to deny that Mr. Brown shot Officer Naim. This matter is also closely to Commonwealth v. McCracken, and it goes on to talk about that case. Again, this is just a lot of the case law. I mean, nailing it on all ends here. The Commonwealth's case rested extensively on the eyewitness identification made by Mr. Hines. The remaining evidence against Mr. Brown was largely based on threats Mr. Brown had allegedly made in the past concerning retaliation against police and an alleged hit list. If such evidence were alone sufficient or significant, then there was just as much, if not more, compelling evidence concerning Two Sweet Smith, who repeatedly threatened and promised to kill an Elko police officer. Based on Mr. Hines' statements and Dorsett's information, Mr. Brown is entitled to a new trial. Mr. Brown is entitled to a new trial based on after discovered evidence in the form of recantation of a statement to police from A.C. Taylor, Mr. Brown's co-defendant. Mr. Brown incorporates by reference the prior paragraphs as if fully set forth herein, although Mr. Taylor did not testify because the co-defendants did not testify against each other. His coerced statement to police that implicated Mr. Brown was introduced with reference to, quote-unquote, the other guy. Mr. Taylor's recantation is substantiated evidence of Mr. Brown's actual innocence. This evidence was not available at the time of the trial, since Mr. Taylor could not be compelled to testify. Therein, The Superior Court reversed the denial of the PCRA relief based on after discovered evidence, despite the PCRA hearing determining that the witness who testified was of questionable credibility and involved testimony inconsistent with abundant trial evidence and was not likely to have changed the outcome of the trial. Again, he's going into case law here. A lot of case law. And okay, so this is a really good part of it, as I'm going to be wrapping it up here. Despite the fact that information was never provided to Mr. Brown during his prior PCRA proceedings, even after Mr. Brown requested discovery. So that's another big part. Remember, he requested all of that stuff, and they denied it. That could have potentially revealed such information. The Commonwealth's failure to provide this Brady evidence during the course of previous PCRA proceedings is particularly where Mr. Brown has repeatedly asserted that Two Sweet Smith was responsible, and that the Commonwealth also failed to turn over wiretap information in which Two Sweet Smith's brother, and upon information and belief that their uncle discussed the heater with the pig thing, the 5-0. The Brady evidence is plainly material as it is exculpatory evidence. Further, the evidence is highly reliable because it involves a federal plea deal in which Mr. Dorsett was required to provide truthful information concerning aliquot homicides. And his statements were used to investigate and convict other individuals for other crimes in Beaver County. Had this evidence been provided during Mr. Brown's prior PCRA proceedings, there is a likelihood that the outcome of those proceedings would have been different and he would have been granted a new trial. In the alternative, even if the Dorsett information would not qualify as Brady evidence because his statements were provided in 2009 after Mr. Brown's trial, it still plainly meets the after discovered evidence test outlined above. The evidence is not cumulative or corroborated of any evidence introduced in Mr. Brown's trial. The evidence is obviously not solely impeachment evidence and is exculpatory material evidence of Mr. Brown's innocence. Anthony Two Sweet Smith's confession to Mr. Dorsett could have been a statement against interest and therefore not hearsay. Moreover, counsel could have presented Two Sweet Smith, and if he invoked his right against self-incrimination or denied confessing to Mr. Dorsett, counsel could have introduced testimony from Mr. Dorsett based on the information he provided to law enforcement as part of his federal plea deal. Mr. Brown could not have been aware of Mr. Dorsett's statement at the time of the trial since Mr. Dorsett made the disclosure after Mr. Brown's conviction. Further, the Commonwealth, despite Beaver County detectives and Pennsylvania State Police and the Beaver County District Attorneys all being aware of the information, failed to disclose Mr. Dorsett's statement during Mr. Brown's prior PCRA proceedings, even when Mr. Brown's discovery request in his last PCR matter could have encompassed such evidence. I mean, you guys hear that? Further, the Commonwealth, despite Beaver County detectives and Pennsylvania State Police and the Beaver County District Attorneys all being aware of the information, failed to disclose Mr. Dorsett's statement during Mr. Brown's prior PCRA proceedings, even when Mr. Brown's discovery request in his last PCR matter could have encompassed such evidence. There is also a reasonable probability of the likelihood of a different verdict if the jury knew that other person confessed to the crime, especially where the jury acquitted Mr. Brown's co-defendant and entered a compromised third-degree murder conviction as to Mr. Brown. Mr. Brown is entitled to a new trial. Counsel intends to call the following witnesses: A.C. Taylor, Darnell Hines, Dorset, Two Sweet, Percival, Detective Anthony McClure, and Michael Warfield. This list may be amended based on further information learned during the course of the proceedings. Witness certifications are attached and or will be provided. I certify that this filing complies with the provisions of the public access policy. Sign. Statements, everything. Sign. All the evidence is in there. And guess what? How does one read this? And think that, number one, that Jamie Brown doesn't have an attorney and that he is filing pro se. Number two, that this doesn't get sent out to the right address of any parties, and that merely by checking the docket is how anybody was informed that on September 30th, 2021, that Judge Mancini denied without hearing. And you then have 20 days to respond from September 30th. But counsel wasn't aware of this until last week. Now, the only way, this is all fact, the only way that Beaver County and people in powerful positions can start being held accountable is if this stuff goes state and national. So this is my plea here to anybody out there that can share this information, that could get it in the right hands of organizations that can help. But I'll be working in overdrive to get this news and this petition into the hands of public figures that help people like Jamie Brown. It's disgusting what people are using their platforms for. Here's a guy, just like all of us. He's not going to claim to be an angel, as he stated. He was young, making stupid mistakes. But no, he's not going around killing people, especially police officers. Jamie Brown is innocent, and Beaver County cannot have this come out. Beaver County can't have what Sunset Secrets is uncovering. Because if you think this is about Two Sweet Smith, it's not. I'm going to prove that. Like I've been proving it. But where does Two Sweets fall into it all? Oh, he's there. But it's way more than that. So Jamie Brown needs our help. This needs to get into the hands of media that's for once going to actually do their job. The media in Pittsburgh, they all just collect a paycheck. They're not looking to try to do the right thing. I've gone back and looked at people's Twitters, looked at people's Instagrams, looked at all of these media outlets in their social media platforms, and then looked and truly, when they say that, oh, this is our investigative journalist, wait, what? What are you investigating? What are you helping? What have you done? And the answer is nothing. A police officer was ambushed and murdered in 2001. Don't we think that a police officer deserves proper justice and the truth? When is actually somebody in Beaver County going to do the right thing? Because it hasn't happened. And I'm hoping that Judge Mancini, after getting the response from Jamie's attorney, does the right thing and has a hearing. The reason it's not Judge McBride is because he's no longer, he retired. When are people going to start doing the right thing? That's the question. And when are people like you and me going to start helping? If somebody knows somebody, like I said, get this into the hands of the right people. Something like this should go viral. How is something like this not viral? But something like hunting for Brian Laundrie is. And news outlets recording Brian Laundrie's parents, or dad, I should say, mowing the grass. All these people using all their time for the manhunt of Brian Laundrie, that is not going to affect one way or another the justice that should and will prevail for Gabby and her family. Because evidence will do its job in the courtroom. But all these news media outlets reporting on a manhunt of a man that's wanted for credit card fraud. And here we have a man, what, is he not white? Is that why nobody cares? Because he's not white? Well, how about a white police officer? If I need to switch the script for you guys, because you can't help a black person, then how about a white police officer actually getting the justice he deserves? I know if that was my brother, dad, uncle, grandpa, friend, I wouldn't want somebody that didn't do that to him to be the person that's in prison. The person that I care about lost their life, and they didn't lose it to him. You guys have a fabulous Saturday, but these are the facts. And Beaver County is continuing, the people that you vote for in Beaver County, they continue to bend you over. And it's only a matter of time until the corruption affects you directly. Because everybody's got family. Wherever you live, you got family. And this isn't stopping. This has nothing to do with Alco Police Department being corrupt. Sorry, but that's just... One may think that. But if you think that little patrolmen are calling the shots in Aliquippa, I'm sorry to break it to you, but that's not the facts. And when they have little screw-ups here and there, it's because they're incapable. But it's not because they're some master corrupt motherfuckers. I can promise you that. So all the time that you waste looking for Brian Laundrie, why don't you go and help Jamie Brown with that time? Somebody that actually needs it. Get this to the right media outlets. Mic drop.